two.
Yeah, let me
bills.
just make sure that I clarify this, and then we'll open it up for question. There are two pieces of legislation. The legislation that Representatives McColley and Koehler are working on, they've been working on for several months now. And the fact that this report was issued, and we felt we needed to respond in support of what the Attorney General was saying to narrowly tailor our piece of legislation is narrowly designed to look at requiring the Department of Health to clarify rules so that there's no mistake of what we expect to happen with aborted children. And so ours is, the one piece of legislation that we're discussing here today is very narrow. Their legislation is more broad and encompasses more issues. So you'll see us bouncing back and forth as we attempt to answer any questions based on that.
So as it relates to your bill, hospitals as well as abortion providers would be required to either cremate or bury fetal remains.
Correct. So one of the things that we've uncovered through this process is that the rules with regards to what happens within a hospital facility are much more defined than what they are within any other facility, and so this will clarify both through the Ohio Revised Code and Administrative Code what those procedures are.
So if a woman has a miscarriage at a hospital, the fetal tissue would be disposed of either by cremation or by burial?
Correct.
Would that be up to the mother then?
It is up to the mother.
Okay.
Could you define what you mean by burial, and also require the hospitals and abortion clinics to cancel contracts that are already in place and negotiated?
Quickly with regards to the contractual information request, and then I will turn it over for them to define with a little bit more depth the idea of burial or cremation. Certainly contracts would need to be looked at and adjusted so that we're making sure that any contracts that are out there are in fact compliant with state administrative and state and Ohio Revised Code, which would presumably be the interested party's goal anyways. But certainly, you know, the idea that we have less of a chain of custody for what happens to an aborted child than we do with a document that has your personal information on a piece of paper seems incongruent with what we should be looking at.
Would it invalidate an existing contract, or would that be something that happens when the contract comes up for renewal?
I certainly am not an attorney, nor have I read their contracts, but generally speaking, most contracts of this nature would have somewhat of a clause in there that would speak to changes in laws that would make the contract need to be reopened and re-engaged upon.
And the definition of burial?
I will let Representative McColley talk to that.
Thank you for the question. Basically, the definition really is interment is the term that we use throughout the bill, and essentially means the burial or entombment of fetal remains is what the definition we are using. And cremation has the same meaning as defined in section 4717.01 of the revised code.
Could a landfill qualify as long as it's underground?
I would say no.
And I would suggest if it does, it won't when we're done with the legislation.
Yeah, I would say that if it's not taken care of specifically in the bill, then it's going to be taken care of specifically in the rules.
In 1986, Planned Parenthood versus Cincinnati, a similar bill that required either interment or cremation was tossed out, or a law actually was tossed out as unconstitutional because it made the procedures, the abortion procedures, cost prohibitive. The cost for the internment or for cremation was added to the cost of the abortion procedure. Is that going to be the same case? Does it give you pause, concern that this could also be tossed out by the courts?
I would have to look at the facts specific with that case. You know, as an attorney, I'm not going to go and comment specifically on that case as
But would
related
the
to this
cost
case.
for burial or internment be passed on to that mother?
No, actually in the bill it says the cost would be borne by the actual provider.
In both cases, in both bills, or?
In both bills, yes. And this was something that was briefly discussed when we had the conversation with regards to the hospital facilities. And, you know, it's not 1996 anymore, and we just need to look at things differently.
Does the health department collect the names of women who have abortions now?
To my knowledge, and I say this based on the information that the Attorney General had commented in his report, that was part of the conversation with regards to whether or not any body parts were sold or gifted when he was doing that investigation, is that it was impossible to track down exactly the exact numbers and identify, particularly in the containers that were then turned over to those that were disposing of them. So I would suggest no.
Why in this bill do you want the names of women having abortions?
It's my understanding, and please correct me if you want to jump in, but on ours, we are not asking for that at all. In theirs, the documentation on how they want the child to be disposed of, either cremation or burial, goes into their own medical records, which are then protected under HIPAA rules internally within the facilities. So they would not be necessarily turned over to the state.
So in this second bill, those names would not be passed on to the health department?
It's not my understanding that that's the intent of the bill. I'm looking through it right now to see if there's anything that would demonstrate that. I think the only thing that we have in the bill is a requirement that on an aggregate basis, you're saying, you're providing, this is how the disposition was carried out. There's nothing in there that requires specific person-by-person names and information to be disposed of to the Department of Health. And if there is, then we would remove that.
Is there any plan to add that? Because you just said that you don't believe that is the intent of the bill.
Well, like I just said, if there is anything in there that's ambiguous, that would lead one to believe that, or lead the ultimate interpreters to believe that we want specific individual names, that will be removed.